U.S. immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions, and I have a good topic for you today. So, I have been taught, I always talk about ways that you're able to stay in the United States and get your permanent residence while being here, even if you're already out of status. And there is a special provision under the INA called Section 245I, where individuals can apply for adjustment of status, even in a situation where they have accrued unlawful presence, where they usually would not qualify for adjustment of status. There are specific requirements for this, and I'm going to list those requirements out. But this has served as an alternative for some individuals to still gain permanent residence through adjustment of status if the 245I applies to them. So here's the first thing you should know about this. To qualify for this, you will need to be able to show that you had a petition or either an employer petition or a family-based petition or a labor certification. That's where an employer is sponsoring you and they first have to file for a labor certification. You have to show that this was filed on or before April 30th, 2001. If you can show that, then it means that you're one step closer to getting permanent residence, even if you cross the border without permission, even if you overstayed your visa, and even in the case that at this time you may not, you ordinarily wouldn't qualify for adjustment of status. So, and this applies, by the way, if you were listed as not only the principal applicant, but if you were the beneficiary on this application. So if you're the beneficiary on this application, meaning you are the qualifying spouse or the child, and there was a petition that was previously filed for you on or before April 30th, 2001, it means that you're able to apply for this relief as well. The other is there is an additional requirement if this petition, this previous petition was filed by a family member, was previously filed by an employer, and it was filed between the dates of January 15th, 1998 and April 30th, 2001, it means that you do have to show an additional requirement. You have to show that you are physically present in the United States on December 21st, 2000, in the year 2000. If you can show these requirements, and keep in mind that that additional requirement applies to the labor certification, to the applies if the labor certification or the previous petition was filed between the dates of January 15th, 1998 and April 30th, 2001. Otherwise, you just have to show that the petition was filed on or before April 30th, 2001 without necessarily showing the physical requirement if it wasn't filed between those dates. Now, what it means, so if you do fall under this category, and I know it's been many years since 2001, but there's these, and even though it's there are fewer and fewer immigrants that are qualifying for a Section 245I adjustment of status, I still want to let you know, because if you have been in the United States around that time, or if you had a petition filed for you or a labor certification filed for you before those dates, and you came into the country without permission, you normally wouldn't qualify. This could be your chance to qualify here. And it is a provision that not a lot of people know offhand. You really have to be practicing, like I am a practicing attorney, to know about these exceptions to the rules. And this is one exception. Now, say you've had additional issues. Say you have maybe been arrested, maybe you have become inadmissible based on other immigration violations. You can still stay in the United States and apply for forgiveness for those. So you still would not have to leave if you qualify for this adjustment of status. When I say adjustment of status, I mean you stay in the United States and apply for permanent residence while you're here without the need to leave. So when I talk about adjustment of status, that's what I'm talking about. And this would allow you to gain forgiveness for any other immigration violations. Of course, we'd have to see what those are, because they're the types of forgiveness that are available depends on what the violation is, whether it's criminally, whether it's in other ways, whether it's in relation to an immigration violation. But the waiver is available, may be available to help you to continue to stay here and apply for permanent residence. Now, once they determine you qualify, and the officer does, grant an approval based on their discretion as well, there is still a fine of $1,000 that you'd have to pay, but which is, in my opinion, is a small cost um, for the compared to the benefits that you get. The fact that you normally would not qualify for adjustment of status, but now you have this 245I that helps you to qualify. $1,000 compared to all the other pains that you would have had to go through is definitely worth it. Now there has been talk, about this possibly being a solution for immigrants who have for immigrants who are here. They don't fall under Section 245I, but there have been suggestions to update, for Congress to update Section 245I to change the date, to maybe bring the date backwards or forwards. So bring it maybe more into the 2000s so more people can qualify for this, because even though it is a valuable form of relief and a valuable provision that helps people who don't usually qualify, because there are there are fewer and fewer people who have had previous petitions filed in the year 2000 and forward, on or before the year 2001. This relief is not really available to current immigrants who have been here for a long time, but not necessarily before 2001. And so there has been talk, or encouragement for Congress to take action and at least push the date backwards, or forwards, I should say, forwards into the 2000s, maybe to assist more people to get this kind of relief. Of course, the conversation about immigration reform and relief is very controversial in the political arena right now. And so there was a lot of talk about immigration reform, that there is still a lot of talk, but because both sides are just not able to agree on any action, we have yet to see, or we have to continue to wait to see what will happen with immigration reform. And it is also based on who takes over, right? Right now, the House has a majority, a narrow majority, but they have majority Republicans. And the Republicans, this is more on a party line. A lot of them are voting along party lines, which means many of the Republicans oppose reform that would give widespread relief to individuals. And so if in 2 years, or less than 2 years at this point, if now they take over Senate, they take over the House, and we have a president who's a Republican, then that could spell disaster for the movement to get meaningful immigration reform that will help immigrants. And we will surely take steps backwards. So whether we move forward, whether there will be relief for individuals who are currently here now who don't necessarily fall under this Section 245I, is really dependent on where we go politically, which party takes majority. The Democrats are more in favor of meaningful immigration relief and reform that will help, for example, DACA recipients and those who have been here for a long time who are in desperate need of relief. For now, what we do have though is we have section 245I. And 245I, even though fewer and fewer immigrants are able to apply under 245I, I still do feel obligated to make sure you know about this, because you may have been a beneficiary. You yourself may have had a filing on or before April 30th, 2001 that could grant you the ability to file for adjustment of status. One more requirement that you need to keep in mind about those, even though this does forgive you if you cross the border without permission or you overstayed and now you're here without status, you still do need to show that you have an immigrant visa number that is currently available, that will be currently available, meaning your priority date is current. So if your priority date has yet to be current, you have to wait for it to be current before you can file for the adjustment of status. So I'm going to reiterate the requirements again, just so that you hear it. And if this applies to you, go ahead, give us a call. We can help you to move forward in this process. Or if you know someone who this may apply to, go ahead, tell them, share my information. And also like, subscribe, follow, share, tell others that I am here around lunchtime to talk about different issues and also to answer your questions. So go ahead and do that now. Let's go over the requirements of 245I. 245I is important because it allows those who wouldn't normally qualify to stay here and apply for a permanent residence through adjustment of status to do exactly that, to stay here, get the green card without the need to leave. Now, it's going to apply to individuals who had a petition, a family petition, or an employer petition, or a labor certification. Labor certification is something an employer had filed, would have filed for you if you were being sponsored by the employer. Now, if the labor certification was filed on or before April 30th, 2001, then that's the first step. It means that you may very well qualify for Section 245I adjustment of status, that you could stay here and apply for the permanent residence. Now, if this petition or the labor certification by the employer or the family member was filed, and keep in mind that you don't have to be the primary immigrant who was on the filing. You could also be the child that was on the filing. So if you were a minor or child, or you could have been the spouse on the filing, then that would still apply to you. Then the other is if this filing was done between January 15th, 1998 and April 30th, 2001, then it means that there is an additional requirement to show that you are physically present in the United States on December 1st, 2000. So there's that additional requirement there. Now, if you do, and you also have to have a current priority date and immigrant visa number that is available to you. If you do meet these requirements, it means that you could move forward with adjustment of status, even if you overstayed, even if you cross the border without permission. And there are waivers available for other types of immigration violations or problems that you may have had, that we could apply for at the same time. And then, all being well, you will also be required to pay a fine. The fine is $1,000, but I often say that compared to the benefits that you get, this $1,000 fine is certainly worth it. But you would not face any further penalties for being here without permission or overstaying or crossing the border without permission. Thanks so much for the love. I appreciate it. So go ahead, give us a call. This is what we work on for our clients. We do help our clients to find our qualifying clients to apply for ways to stay in the US without the need to leave. And this is one of those important forms of relief that is currently available. Of course, there are other types of relief, and you'll hear me talk about them. VAWA is one of them. Adjustment of status if you're the immediate relative of a U.S. citizen, and if you have the T visa or the U visa or asylum, these are other ways you can stay here, apply for adjustment of status without the need to leave. All right. So now I'm going to go to questions. I see questions coming up. So go ahead, put your questions in the comments. I am going to answer. So I'm into a marriage 6 months. It's not working out. I've already filed and I'm waiting on my EAD. It's a good idea to transfer it to VAW, or should I wait for EAD and AP before doing it? Go ahead, give us a call. This is urgent, and I often say get it done right now. Means that your process will continue. The faster you do it, is the better it is for you, and the smoother it will be for the rest of your process. So get it done now. It does not necessarily affect the processing of the work permit, but if your spouse decides to intervene, contact them, cancel the petition, then they could cancel the adjustment of status, and then that would cancel the employment authorization. So the faster you do apply for VAWA, is the faster you're able to take control of your own process and make sure that you protect your process as the EAD is continuing to be processed. So this is where you should go ahead, give us a call, and we'll schedule. We'll go ahead and get started as soon as we just make sure that we can take your matter. I have received my receipt on VAWA. Please, what should I be expecting? So usually, while I'm not your attorney and I don't know your case, usually the next step is the biometrics, which is the fingerprinting appointment. All right. Okay, do you help with the fiance visa? Absolutely. I just I have a video just this morning that talks about the pros and cons of the fiance visa. So go ahead. You can always give us a call, schedule so we can see if you qualify, and then we can get started. So if you cross the border and they take your passport and they still allow you to stay in the country, will I be able to get it? So there have been widespread reports about them taking your passport. Whether or not they can take your passport is going to be dependent on the circumstances. If you were paroled in and they took your passport, then that could be a problem. So, it's just going to depend on the situation. In some other situations, it is a practice for them. For example, if you were detained, for them to take the passport until you finish your deportation process or removal hearing, and they wait for the results of that. So it all depends there. Uh, okay, keep those questions coming. So if you and your spouse been married 3 years without a green card, can you apply straight for citizenship? No. You must, before you apply for citizenship through a spouse, you must first become a permanent resident. And then from the date, they count 3 years from the date you become a permanent resident to be where you can apply. You'll never automatically become a US citizen without first applying, unless of course you get it through a parent, but you're never going to just become a US citizen without first becoming a permanent resident and going through the time requirements. Um, how do you know someone has you on the filing? So, it's going to depend that you would think that your relative or the employer is going to tell you that you're on the filing. Otherwise, there are other ways that you'd have to find that out. Possibly through a FOIA request if this is something that was never disclosed to you. But ordinarily, the way things work is usually the family member or the employer is going to tell you that you're included in the filing. All right, great question. So thanks. Please, how long does it take for biometrics? It all depends. It could take anywhere from a month to 2 months to get it, but keep in mind these are just time. These are just estimated timelines. If an American citizen spouse was arrested for gun when he was 17, will it affect the process for the immigrant spouse? So I suggest that you get legal advice, especially when it has anything to do with criminal situations on both ends, the spouses and as well as the immigrants' side. There are concerns in regards to what's called the Adam Walsh Act because they want to ensure the safety of the immigrant spouse. Um, and so it's going to depend here on, what was the nature of the gun possession, and was the 17 that he was 17, he was a minor at the time. What was the resulting charge? Was he convicted? Did he go to juvenile detention? And then did it involve another minor involved in this? So, always when it comes on to criminal matters, always get representation because it can get messy and complicated pretty quickly, and you won't see it coming if you don't make sure you're represented. If your spouse has So if your spouse has been here for more than 2 decades but has not filed for citizenship, will that affect the immigrant spouse? Um, no, no, not necessarily. It won't affect the immigrant spouse, but it depends. Affect the immigrant spouse how? What is the immigrant spouse applying for? Are they applying? Is the legal permanent resident spouse applying for the immigrant spouse's papers? So it's going to depend. Please elaborate there so I can answer that in a better way. What can be done if you are ready to file for your citizenship and you didn't sign up for selective service before 26? So men are the ones that are required to sign up for the selective service. And you're not supposed to willfully neglect to sign up for selective service. But if the person is a man, because it only applies to men. But if they were between the ages of 18 and 26 and they didn't sign up, they do at a minimum have to provide an explanation for it. And it's going to be up to the officer to determine whether they're going to accept that explanation. And then in some cases, if the individual went to high school, the school may have automatically signed up the student, and maybe the student may not even have been aware of that. So it's what we do is in cases like this, we do check. There are ways to check the selective service. There's a specific number that they assign to see if they did sign up for it. But it can raise some issues. It just depends on the reason. Where was the person? Where were they, the immigrant, at the time they were supposed to sign up? If they were not a resident of the United States at the time, then they would not have been expected to sign up for selective service. But as usual, in cases like this, when in doubt, get representation. It does make a difference. Can someone apply for a visitor visa while their I-130 is being processed? There's nothing that says they can't. You're facing an uphill battle to get the visa with a pending I-130. You really have to come good to explain to the officer why is it that they shouldn't assume you have immigrant intent with a pending I-130 to get your green card to live permanently in the United States. It's not unheard of for individuals to get the visa while an I-130 is pending, but it really comes down to what kind of evidence does the officer have in hand to show that you will not just come up here and stay, because that's their number one goal, is to stop you from doing that. Um, How long are I-130 spousal cases currently taking? So I'm seeing 9 months to 12 months. And that's if the spouse is outside of the United States. It's shorter if they're in the United States applying for adjustment of status. Um, so applying for legal status, but my spouse is not permanent, is still not permanent resident for over 20 years. Can we go ahead and get married and file papers? Wow. So that is a very loaded question and it's too specific. Make sure you schedule an appointment. That's too specific, and you need to make sure that you get specific legal advice. All right. So keep those questions coming. These are all great questions. Put your questions in the comments and I will go ahead and answer. All right, so in the meantime, while I wait for your questions to come in, I'll tell you how to get in touch with me so you can schedule your appointment to talk about your particular issues, or what how you want to achieve your goals in the future. Now, you can go ahead, go to the link in the profile, click on that link. You will see, and click on the link in the profile. You can also click on the link in the description of this video. You'll be able to schedule your own appointment without even calling. If you do want to call or go to the website, you will see the phone number, you will see the contact form, you'll see online chat. All three of them lead to the scheduling coordinators who will be more than happy to assist you with your appointment to get it scheduled so we can talk and get started on your matter as soon as possible. How long does it take to get the ED card after you do the biometrics? So it's hard to say after the biometrics because the biometrics are all over the place right now. But I would say from the time of filing, it depends too. It depends on what case type you're looking at. For family based adjustment of status, you're looking at anywhere from 6 to 8 months. For the VAWA, you're looking at 6 months to up to 12 months. What is some type of bona fide marriage evidence to submit when your spouse lives overseas? So if you're living overseas, there's not usually they have less of an expectation that you're going to be living together, but it's going to be the same as other spouses. If you are married, you definitely do have things going on for you together, right? You have you exchanged money, you have seen each other often, you probably call each other often, you've given each other gifts, right? So it's going to be evidence like that. Affidavits, properly written affidavits from friends and family on both of your sides talking about what your marriage is going to be, other good evidence in this case. Um, if you and your spouse been married 3 years without green card, can you apply straight for citizenship? No, you can't. All right, so that's going to be it for me today. Thanks so much, everyone, for joining me. Thanks for your time. I will be back tomorrow at around lunchtime, so between 12-12:30, where I will continue to take your questions and have a good conversation with you. So thanks, everyone, for your time. I'll see you tomorrow, and always know that you can get in touch to schedule your appointment so we can talk about your particular situation. All right. Have a good one. Bye bye.